Welcome to Child Abuse Awareness with Darlene J. Clark. Welcome to Child Abuse Awareness with Darlene J. Clark.
Hello and welcome to another episode of Child Abuse Awareness. Darlene J. Clark. Be a part of the solution instead of part of the problem. I saw this on, I want to thank a friend of mine for sharing this with me. There's a victim, this Victor Renato Blythe, age 61, from Washington, D.C. He was a psychotherapist, was employed. So let me go ahead and let me share with y'all first of all. Let's get the information out there. It is also in my descriptions. So they're seeking victim information in Victor Renato Blythe investigation. The FBI Washington Field Office is seeking to identify potential victims of Victor Renato Blythe, who was recently charged with distribution and possession of child pornography in violation of 18 USC. I don't know, want to go with all the numbers right there, which you can see it. Blythe was a licensed clinical social worker who specialized in working with children. He previously worked for the psychiatry department at Children's National Hospital for 7 years. I guess he still has that degree, So if you or your minor dependents have information about Victor Renato Blythe, please fill out the short form so that the FBI can contact you. If you know of someone else who has possibly been victimized by Victor Renato Blythe, please encourage them to complete the form themselves. The FBI is legally mandated to identify victims of federal crimes it investigates. Victims may be eligible for certain services, restitution, and rights under federal and or state law. Your responses are voluntary but may be useful in the federal investigation and to identify you as a potential victim. Based on the responses provided, you may be contacted by the FBI and asked to provide additional information. All identities of victims will be kept confidential. That is very important to know. It also gives you at this website the additional resources. DOG Office for Victims of Crime, Help for Victims, National Safe Place Network, National Child Traumatic Stress Network, National Suicide Prevention Lifeline, 1-800-273-8255, Rape, Incest, and Abuse and Incest National Network, RAIN, with an extra N, National Center for Missing and Exploited Children. Here's your contact information. So wherever there's a red, that needs to be put there. It's important to put it there. I am filling this form out on behalf of myself, my minor dependents. You go on down here and you fill out this information. I am not a robot. You just got to make sure to validate who you are. The Privacy Act statement suggests. So without further ado, Next, I want to go. Thank you so much. I appreciate you, girl. Lots of love. Try to get this bigger. Okay. Screen just keeps going too small for me. All right. Get ready for this. Now I'm going to play the video of Judge Janine Shapiro. Trigger warning. All right.
61 years of age, who today was sentenced to 10 years in prison for a horrific crime. 300 videos, images of young children, victims, toddlers, infants being sexually abused. The outrageous, even more outrageous part of all this is that the defendant worked in the psychiatry department at Children's National Medical Center, and he spent years in that position trying to gain access to children so that he could attempt to sexually exploit them. This is a horrific case. The evidence was solid. Not only did he take pictures and direct individuals on what to do in a video, but he also trained someone else to teach them how to groom young children. So let this be a message to the dirtbags out there who are pedophiles, who want to abuse children, that don't do it in DC, because we're going to catch you and you're going to spend a lot of time in prison. And I'll bet you're not going to have a good time there. Thanks for watching.
So what do y'all think about this so far? Isn't that ridiculous? I don't think that 10 years is enough. When he was a psychiatrist and he went and worked over there around our children, I think people scum like this, they need the death penalty. I want to say, where's my friends with the wood chippers, right? Now let me go and give out a little bit more information here. So here's the documentation when we go more and delve into this case. Okay, here's the United States District Court with the District of Columbia. Victor Renato Blyth, defendant. Victor Blythe is charged with distribution of child pornography in violation of 18 U.S.C. and possession of child pornography in violation of. Before the court is Blythe's motion to suppress evidence discovered as a result of the search of an iPhone seized from his residence. See docket 22. For the reasons that follow, the court will deny the motion. Put in mind, he also had tried on Skype talking to a 15-year-old and sending him pictures of his penis, such and such. The FBI's Child Exploitation and Human Trafficking Task Force first became aware of Blythe when it received from the Fairfax County Police Department information related to an individual the department had arrested, CD, with whom Blythe had been communicating. There's the evidentiary hearing, 18-825. You look there. In particular, the department provided the task force with electronic messages from CD and Blythe that discussed their sexual interests in minors and appeared to involve the exchange of child sexual abuse material. So I guess CD's the one that he groomed, that told him how to go about grooming the children. That's what I'm assuming, okay? The FBI obtained a search warrant for Blythe's residence in Northwest D.C. The search warrant permitted agents to seize electronic devices, including cell phones. As to those devices, the warrant provided during the execution of the search of the premises, law enforcement personnel are also specifically authorized to obtain from Victor Renato Blythe, but not in any other individuals present at the premises at the time of execution of the warrant. The compelled display of any physical biometric characteristics such as fingerprint, thumbprint, facial characteristics, or iris display necessary to unlock any device, requiring such biometric access subject to seizure pursuant to the warrant for which law enforcement has reasonable suspicion that the aforementioned person physical biometric characteristics will unlock the device. Law enforcement are authorized to attempt to unlock any such device security features in order to search the contents as authorized by this warrant by compelling the display of such a physical biometric characteristic. That is, by pressing or swiping the fingers or thumbs of the aforementioned person against a fingerprint scanner of any such device, and or by holding in front of the face or the aforementioned person to activate the facial recognition or iris recognition feature of any such device. Then at the same time, the warrant contained the following restriction. While attempting to unlock the device by use of the compelled display of biometric characteristics pursuant to the warrant, law enforcement is not authorized to demand that the aforementioned person state or otherwise provide the password or identify the specific biometric characteristics, including, including the unique fingers of the other physical features, that may be used to unlock or access the device. Nor does a warrant authorize law enforcement to use the fact that the warrant allows law enforcement to obtain the display of any biometric characteristics to compel the aforementioned person to state or otherwise provide the information. So let's get on down further than that. In other words, under the terms of the search warrant, agents could compel the display of Blythe's physical biometric characteristics, but they could not order Blythe to unlock a device. Or add two new, sorry, get tongue tied, a little upset about this. Or two, ask Blythe for information regarding how to unlock the device, or state or imply that the warrant required him to provide such information. Materially, similar parameters were detailed in paragraphs 49 and 58 of the affidavit in support of the warrant application. The terms of the search warrant required the FBI to execute the warrant within 14 days. The FBI executed the search warrant at approximately 6 a.m. on August 12, 2025. FBI Special Agent Blake Renato, the lead agent investigating Blythe's case, was present on the scene, along with over 20 other law enforcement personnel from the FBI, Metropolitan Police Department, and Fairfax County Police Department. FBI agents approached the residence with weapons drawn. Agent Renato carried a rifle and a battering ram. Another agent carried a tool that would spread open the door to allow the agents to gain entry to the residence. Within approximately 20 seconds of personnel announcing their presence and knocking on the front door, agents began forcibly breaking the door using the battering ram and tool. After the door had been forced open, Blythe emerged from a room in the back right of the house wearing only a t-shirt and socks. Agents ordered Blythe to put his hands up and walk backwards towards the door. When Blythe reached the front door, an agent placed him in handcuffs. Agents asked Blythe who else was in the home. Blythe responded that his brother was inside. The agents asked where in the home his brother was located, and Blythe answered that his brother was in the basement. An agent yelled for Blythe's brother, Robert Blythe, to come to the front door. An agent walked Blythe to an unmarked police vehicle parked in front of the residence, where Agent Tanya Griffith, a certified digital extraction technician, and the search team lead waited. It goes more numbers right here. The Agent Griffith and another agent, both armed, stood with Blythe as the agents secured the home. Agent Griffin advised Blythe that the FBI had a search warrant and that agents would explain more once the home was secure. Although she denied Blythe's request to sit inside the vehicle and to go back inside, she positioned Blythe behind the vehicle's door and stood behind him to attempt to provide some privacy and shield him from view. Agent Griffith asked Blythe whether his brother was in the basement level of the home. Blythe confirmed he was. The agents later asked Blythe to describe the location of his brother's bedroom, and he did so. While Agent Griffith and Blythe waited outside, agents continued to secure the home. Once the main level of the home had been cleared, a group of agents exited the residence and went to a basement level entrance in the rear of the home. An agent called for Robert Blythe to come to that back door. Although Robert Blythe emerged from an interior room and was visible through a window, he did not immediately open the door. Agents broke open the basement door, handcuffed Robert Blythe, and took him outside the home. Approximately 13 minutes after Blythe was escorted to the vehicle to wait with Agent Griffith, an agent announced that the home was clear. Agent Griffith escorted Blythe, still handcuffed, back inside, bringing him to a sitting room on the main level of the home. She did not advise Blythe that he was free to leave. An agent removed his handcuffs, and Agent Brothnell brought him a pair of shorts. Agent Brothnell introduced himself to Blythe and explained that the FBI was executing a search warrant. He told Blythe that he wanted to speak to him and gave him the option of speaking in the home or outside in a law enforcement vehicle. Blythe chose to speak in the vehicle. Agent Brothnell and Blythe were joined in the vehicle by Special Agent Matt Lee. The agents made an audio recording of the interview, which lasted approximately 12 minutes. At the outset of the conversation, Agent Brothnell explained that he and Agent Lee worked on the FBI's Child Exploitation and Human Trafficking Task Force and had a search warrant for Blythe's home. Agent Brothnell read Blythe his Miranda rights, and the agents explained that Blythe was free to leave, that his participation in the interview was voluntary, and that he could terminate the interview or decline to answer particular questions at any time. Agent Brothnell proceeded to give Blythe high-level background on the investigation and explained that the search warrant permitted them to collect certain electronic devices in the home and to review their contents for child sexual abuse material. After Agent Brothnell collected Blythe's biographical and contact information, the agents asked Blythe a series of questions regarding his relationship with CD. Agent Brothnell explained that they had read basically every text message that Blythe and CD had exchanged over the past 5 or 6 years, noting that the messages included attachments and links. Shortly after Agent Brothnell asked Blythe to provide background on the nature of those attachments and links, Blythe stated that he wanted to speak with an attorney. I bet you do. Or did. Agent Brothnell and Agent Lee terminated the interview. Agent Brothnell told Blythe that it would take FBI agents approximately 1.5 to 2 hours to finish searching the home. He also told Blythe that he was free to leave the premises while the search continued. He further explained that if Blythe chose instead to stay in the home, he must remain within one room. Blythe chose to stay in the home. Blythe was escorted back to the sitting room on the main level of the home, where he took a seat on the couch that agents had cleared. He was not re-handcuffed. After Blythe returned home inside, Agent Griffith entered the sitting room with an iPhone that she had located on the floor in a main level bedroom in the back right of the home, same area of the home from which Blythe had appeared when agents broke open the front door. The iPhone was powered on and in the after first unlocked state, meaning that although the phone was locked, the passcode had been entered at least one time since the phone was powered on. A phone in after first unlocked state can be opened using a passcode or physical biometric characteristics. Agent Griffith approached Blythe and told him that the search warrant authorized her to hold the phone up to his face to obtain his facial biometrics. When she proceeded to do so, however, Blythe closed his eyes and turned his head away, said something to the effect of, "I don't want to do this." He didn't want it to be open, y'all. Do y'all wonder why he didn't want to have it open? Poor guy, right? guy. I'm sorry, I'm being facetious. Okay. So Agent Griffith and Agent Brundapple again explained that the warrant permitted them to compel the display of Blythe's physical biometric characteristics. Because Agent Brundapple did not have a physical copy of the warrant with them, he attempted to open a copy on his phone. He read Blythe paragraph 49 of the affidavit in support of the warrant, which authorized agents to compel the display of physical biometric characteristics. He did not read the portion of the warrant or of the affidavit that prohibited agents from ordering Blythe to unlock a device, or asking Blythe for information regarding how to unlock a device, or stating or implying that the warrant required him to provide such information. Agent Griffin again held the phone to Blythe's face. Blythe again indicated that he did not want to comply. When Face ID again failed, Blythe entered a passcode saying it's just easier this way. Agents did not ask Blythe whether or which physical biometric characteristics could open the phone. They also neither asked Blythe to unlock the device using the passcode nor advised him that the warrant did not authorize them to compel him to do so. Agent Griffith saw some, but not all, of the digits that Blythe entered to unlock the phone. Agent Brundapple was not able to see any digits. The phone's passcode prompt screen indicated that the passcode to the phone was 6 digits. Agent Griffith took the unlocked iPhone to a different room to begin an on-screen preview that would allow the FBI to determine to whom the phone belonged and to perform a preliminary review of the phone's contents. When FBI agents reviewed the contents of the iPhone, Agent Brundapple located on the dining room table a laptop that, based on the user profile, appeared to be associated with Blythe. Agent Brundapple brought the laptop to Blythe and explained that he was going to unlock the laptop using Face ID. When attempts to unlock the laptop using Face ID failed, the login screen prompted entry of a password. Agent Brundapple spent some time trying to back out of the password screen to return to Face ID, but he was unable to do so. At that point, Agent Brundapple handed Blythe the laptop and said, "We can try this," as in the password. "We can try the facial thing," adding, "That's up to you." Blythe took the computer, entered a 4-character password, and handed back the unlocked laptop. Fairfax County Detective Blake Albritton recorded on a cell phone a video of Blythe entering the password into the computer. An Agent Brundapple left with a laptop. Agent Griffith returned with the iPhone, which had locked while law enforcement was conducting the on-scene preview. Agent Griffith approached Blythe saying, "Sorry, I just need your face again on the phone." Detective Albritton added, "Or you can do password, whatever's easier for you." Blythe took the cell phone from Agent Griffith and entered a passcode, then handed the unlocked device back to her. Agents did not advise Blythe that the search warrant did not authorize law enforcement to compel him to enter the passcode. Detective Albritton also recorded this interaction on video. The video recording captures Blythe entering a passcode into the phone. Agents ultimately learned that the iPhone passcode, that laptop, I don't want to put that there. Agents' petitions for an arrest warrant based on the materials discovered on the iPhone during the on-screen preview included messages between Blythe and CD and images stored on the phone. Blythe was arrested on the scene. Agent Brundapple testified that he did not know the extent of the on-scene preview conducted after Blythe first unlocked the phone. His review of the messages and images, however, took place after Blythe unlocked the phone a second time. Agent Griffin testified that she did not know what content was observed after the first unlock. After Blythe was arrested, Agent Griffin took the iPhone to the FBI facility and connected it to GrayKey, a device capable of extracting data from cell phones. GrayKey extracts data for locked cell phones using various methods. For some cell phones, Gray Key is able to guess the phone passcode using a passcode database. For others, Gray Key is able to bypass the passcode completely. Gray Key is not always successful. Whether it's able to extract data from the cell phone depends on such variables as the state the phone is in, the model of phone, and the phone's operating system. Gray Key also cannot extract certain information from a locked phone, including sometimes the GPS and health data. When Gray Key extracts data from a cell phone, it provides the extracted data in raw form. Other software must be used to view and analyze the data. Because Agent Griffin had the passcode to the seized iPhone, she used the passcode to unlock the phone and performed a full data extraction of the unlocked phone using Gray Key. On October the 2nd, 2025, Agent Griffin checked the iPhone out of evidence to determine data Gray Key would have extracted from the phone during the first extraction had she not unlocked the phone using the passcode. Because the phone had died while in evidence, Agent Griffith plugged it in and allowed it to charge. Once charged, the phone was in before first unlocked state, meaning that the passcode had not been entered since the phone had powered on. On October the 3rd, 2025, Agent Griffiths replicated the active first unlocked state in which the FBI first found the phone in August by entering the passcode and then locking the phone. She then connected the phone to Gray Key and performed a data extraction. The data that Gray Key extracted from the iPhone during the October extraction mirrored in material respects the initial extraction the FBI performed upon seizing the phone. Although Agent Griffin did not conduct a file-by-file comparison of the extractions, she confirmed that both extractions contained the files and messages identified in the complaint, as well as other child sexual abuse material. Agent Griffin testified based on her training and experience, the first data extraction did not impact the second. The extraction profiles would have been the same no matter in the order in which they were performed. Agent Griffin further testified that it is the FBI's standard practice to transport all seized cell phones back to an FBI office and to connect them to an extraction device like Gray Key. It is only in rare circumstances that the FBI does not follow the standard practice, such as when the phone is a work phone or belongs to another individual. If a cell phone is in the after first unlocked state and FBI agents do not have the phone's passcode, agents will keep the phone charged while transporting the device to an FBI office, as it is easier for Gray Key to extract data from a cell phone in that state. The FBI search of the iPhone and of a Samsung storage device, also seized during the search of Blythe's home, remains ongoing. Although the FBI seized a second cell phone during the search, the phone was in factory reset mode and did not contain any data. I wonder if they started putting it in factory reset when they were expecting them. You know what I'm saying? The Fourth Amendment guarantees it is the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. I would not call this unreasonable, okay? While the amendment contains no provision expressly preluding the use of evidence obtained in violation of its commands, that's Arizona versus Evans, 1995, the Supreme Court has established an exclusionary rule that when applicable, forbids use of improperly obtained evidence at trial. Herrick versus United States. When this rule applies, it prohibits the government from introducing in its case a cheap evidence obtained in violation of the Fourth Amendment. The Fifth Amendment provides that no person shall be compelled in any criminal case to be a witness against himself. U.S. Constitution Amendment 5. To qualify for the Fifth Amendment privilege, a communication must be testimonial, incriminating, and compelled. Furthermore, to protect the right against compelled self-incrimination, the Supreme Court has held that the government may not introduce at trial statements made by a defendant during custodial interrogation unless the government demonstrates use of procedural safeguards effective to secure the privilege against self-incrimination. When an individual in custody is subjected to interrogation, those procedural safeguards typically take the form of Miranda warnings, which include warning the individual prior to any question that he has a right to remain silent, that anything he says can be used against him in a court of law, that he has a right to the presence of an attorney, and that if he cannot afford an attorney, one will be appointed for him prior to any question if he so desires. For these purposes, the term interrogation refers not only to express questioning, but also to any words or action on the part of the police other than these normally intended to arrest and custody that the police should know are reasonably likely to elicit an incrimination response. So I'm sorry this is taking a while, but I think it's very important for us to be going over. So give me a minute. I'm going to put it up here so we can see what's. It's taking a while, but I think it's very important for us to be going over. Yes. Hey, Peggy. Good to see you. Thanks for coming in. Hello, Sparrow. So Blythe moves to suppress the evidence discovered on the seized iPhone under both the Fourth and the Fifth Amendment to the Constitution. His primary argument is that the search warrant, which purported to authorize law enforcement agents to compel him to display his physical biometric characteristics, violated the Fifth Amendment right against compelled self-incrimination and was facially unconstitutional. Alternatively, he argues that even if the warrant was constitutional on its face, law enforcement violated the Fourth Amendment because they did not comply with the terms of the warrant. Finally, Blythe argues that law enforcement violated his Fifth Amendment rights by questioning him after he invoked his right to counsel. For the reasons that follow, the court concludes that the search warrant was not unconstitutional on its face. The court further concludes that even if the law enforcement violated the terms of the warrant or Blythe's Fifth Amendment right against self-incrimination, the government has established by a preponderance of the evidence that it would have been able to gain access to evidence on the cell phone using lawful methods. Accordingly, the evidence discovered on the seized iPhone is admissible under the inevitable discovery doctrine. A. The search warrant was not unconstitutional on its face, and Blythe's Fifth Amendment argument relies principally on the D.C. Circuit's recent decision and United States versus Brown. In its telling, Brown makes clear that the use of facial recognition or fingerprints to open an electronic device is testimonial. So let's go further down. We ain't going to read all of Brown's thing because I want to stay focused on this case now, right? Because we know that they went ahead and said it was okay. So let's get to some more important things down here, right? So starting with this physical trait case law, the D.C. Circuit explained that although law enforcement's use of the individual's physical traits is generally not considered testimonial, the inquiry is contextual. The court noted that the Fifth Amendment does not, for example, protect against the involuntary furnishing of a blood sample, submitting to fingerprinting, providing a handwritten exemplar, providing a police exemplar, standing in a police lineup, or donning particular clothing, none of which requires an individual to disclose any knowledge he might have or to speak his guilt. At the same time, however, the court recognized that certain displays of physical traits, such as physiological changes observed during a lie detector test, can be testimonial, as they are tangible manifestations of the testimonial knowledge and thoughts in an individual's mind. But I thought they said that lie detector tests were inadmissible because sometimes they're faulty. Oh, okay. The court reasoned that, though placing a thumb on a phone may seem akin to submitting to fingerprinting or providing a handwriting exemplar, Schwartz compelled unlocking was much closer to responding to a lie detector test or complying with a command to say a password. When Schwartz was ordered to open the cell phone, the court explained his act of unlocking the phone represented the thought, I know how to open the phone. I have control over and access to this phone. and the print of this specific finger is the password to this phone. The court reasoned that Schwartz instead been compelled to disclose whether he could open the phone and made to say yes or to verbally disclose a password, those answers unquestionably would be testimonial communications. Because Schwartz compelled opening of the cell phone conveyed of the same information. So we're going on still with that other person's case with they're still trying to fight what the judge says about that, but the judge okayed it. So let's get on down to the nitty gritty. We're going to see what they found in the search, right? There's another one, and they searched with the United States versus Payne, where enforcement forcibly grabbed the appellant's thumb and used it to unlock a cell phone. I guess they're trying to get upset about them using his biometric of the cell phone that way. The facts before it represented the very scenario that the Ninth Court acknowledged might lead to a different result. The D.C. concluded that its holding in Brown was consistent with the Ninth Court's decision. Okay, the search warrant case was not unconstitutional on its face under the analysis set forth in Brown. The warrant authorized law enforcement to compel the display of Blythe's physical biometrics characteristics while prohibiting agents from ordering him to unlock a device, asking him for information regarding how to unlock a device, or stated or implying that the warrant required him to provide such information. Neither the permissive nor the restrictive aspect of those compelled unlock perimeters ran afoul of Brown. So let's go on down. We can read every case right there that did with the biometrics. Okay. Now let's get down. Blythe resists the conclusion, arguing that the search warrant contravened Brown because compelling the display an individual's physical biometric characteristics discloses the individual's knowledge of and relationship to a seized cell phone. Not to suppress 5, but while the fact that an individual's face and finger unlocks a cell phone may reveal that the individual has control over or ownership of the phone, that information is not sufficient to make the compelled display of such characteristics testimony under Brown. The compelled unlocking in Brown conveyed not only Schwartz's control over the phone, but also his knowledge on how to access it. So when Schwartz was ordered to open the cell phone, his act of unlocking the phone represented the thoughts: I know how to open the phone, I have control over and access to the phone, and the print of this specific finger is the password of the phone. Okay, so basically we know about that. Okay, so even if law enforcement exceeded the restrictions in the search warrants, the evidence discovered on the seized iPhone is admissible under the inevitable discovery doctrine. Woohoo! I like that. Blythe alternatively argues that even if the search warrant was constitutional on its face, that law enforcement did not lawfully execute it. While the court finds the question whether law enforcement complied with the warrant to be close, it ultimately need not decide the issue. Even if law enforcement violated the terms of the warrant, the government has established by a preponderance of the evidence that it would have been able to gain access to the relevant evidence using lawful methods. There goes the warrant's terms. And so we went over that, so we don't need to read it every time. Let's go on down to okay, voluntary disclosure, such information. Okay, execution of warrant, any other the aforementioned person. Okay, there's an impetus. Such information does not, as Blythe suggests, refer generally to all biometric and password information. Rather, the phrase refers to the password and the specific biometric characteristics, including the unique finger or other physical features that may be used to unlock or access a device. Put differently, the warrant prohibited law enforcement from compelling Blythe to provide the password for a device or to identify the biometric characteristics that would open the device. If law enforcement did ask Blythe for any such information, the warrant required them to make clear He was free to decline the answer. This reading is bolstered by the permissive aspect of the warrant's compelled unlock parameters, which specifically permitted law enforcement to compel Blythe to display certain physical biometric characteristics. I think I'm going to get down to the nitty gritty now. Okay, let's see. Get past facial biometric. Okay. The agent's action in the exchange did not violate the search warrant's express terms. Agent Griffith and Agent Prothnaple did not demand that Blythe provide the iPhone's passcode or identify the biometric characteristics that would open the phone, nor did they imply that the warrant authorized them to compel Blythe to disclose the information. The agents simply attempted to compel the display of Blythe's facial biometrics, an act clearly authorized by the warrant's terms. By repeatedly placing the phone to Mr. Blythe's face, agents communicated a demand that he unlock it through a show of authority that contravened the express limitations on their authority articulated in the warrant. Law enforcement made clear that Mr. Blythe had no choice but to unlock the phone. Okay, so we're going to get on down to make clear, provide involuntary to freedom. Okay, the second unlocking, let's see, there's the passcodes. I want to get to the nitty gritty of the pictures. Who's with me? So here's the inevitable discovery. The court need not, however, resolve whether law enforcement's actions surrounding the second unlocking complied with the terms of the search warrant. Even assuming a constitutional violation occurred, the court concludes that law enforcement would have inevitably succeeded in extracting the relevant data from the seized iPhones using lawful means. Okay, let's get on further down. Okay, so let's go. I think I need to read this part right here. The inevitable discovery doctrine allows for the admission of evidence that would have been discovered even without the constitutional source. So the evidence in question would inevitably be discovered without reference to the police error or misconduct. There is no nexus sufficient to provide a taint, and the evidence is admissible. Inevitable discovery involves no speculative elements, but focuses on demonstrated historical facts capable of ready verification or impeachment. To prevail on an inevitable discovery theory, the government must prove by the preponderance of the evidence that even without the unlawful search, the evidence it seeks to omit would have been discovered by lawful means. Here the government met its burden of proving by preponderance of the evidence that law enforcement would have been able to extract the relevant data from the seized iPhone without the passcode Blythe provided. Here we go. I still want to go and try to see where they started getting the material, right? Because it says right here, when Agent Griffith put the seized iPhone into the after first unlock state and connected it to Gray Key in October 25, the content of the extraction mirrored in material respects that of the initial extraction, including with respect to the messages and child sex abuse material identified in the complaint. The evidentiary record established that it indeed wholly speculative that computer investigation and forensics would have ever gained access to either phone's contents, and even then precisely would have been forensically imageable. Blythe argues that the court cannot rely on October 2025 extraction to conclude that law enforcement would have been able to extract data from the iPhone without the passcode. In particular, he contends that the search warrant did not authorize law enforcement to continuously search the cell phone outside of the warrant's explicitly delineated 14-day period. So he didn't want all the evidence really out there. He had so many videos and stuff. Death's first notice of additional authority, docket 29, or to search the cell phone for the purposes of performing an experiment to bolster the government's inevitable discovery argument. Deaths, respect, RESP, to order of the court regarding additional briefing 2 and 3, docket 35, neither argument succeeds. As the defense conceded at the November 13 motion hearing, Blythe's first argument fails under the clear text of Federal Rule of Criminal Procedure 41. The rule provides, in relevant part, a warrant under Rule 41 may authorize the seizure of electronic storage media with the seizure of copying of electronically stored information. Unless otherwise specified, the warrant authorizes a later review of the media or information consistent with a warrant. The time for executing the warrant in Rule 41, C2A, and that other refers to the seizure or on-site copying of the media for information. So right here, you're going on down. Here, law enforcement seized the iPhone within the 14-day time period set forth in the warrant. The warrant did not place any limitations on the time in which law enforcement was required to search the device once seized. So let's go on down there. Let's I want to see where they find this stuff, right? Okay, this argument, however, takes too narrow a view of the scope of the warrant and of the purpose of the October 25 search. The warrant authorized a review of electronic storage media and electronic storage information seized or copied pursuant to this warrant. Did y'all see in her thing how much information and videos that this guy had? And he specifically got this job to mess with kids, to mess with toddlers. Did y'all see this? It's sick and twisted. It's not clear that the data extraction itself constitutes a Fourth Amendment search. Okay, so we're going down further here, right? There's more on the law right here, but the extraction. So I guess this right here basically is just the about whether it was legal or not legal. And it was all legal, right? And it's, how's everybody doing today? I hope you're doing well. So I want to try to get back and find this other article that I had prior. So let me look him up again. Victor Renato Blythe. I first spelled it wrong. Y'all, I put BLYTH and not with an E. So please forgive me on that. Licensed clinical social worker. Document that's 22 filed right here. I wonder if this is one that I had right here. Checking it out. All right. Okay, this is where the appearances also with Victor Blythe, United States. Appearance was Cheryl Storm and Daxter. Vision court order. Okay, let's see. Okay, so now this ain't the one I wanted. Sorry. Trying to find it again. I'm sorry for having this. I had seen it on the Gov website. So I'm trying to find it there right quick. I don't want to go back over the case thing. So this actually was in the judicial publications, the collection United States Courts Opinions, and the class number is JU415, district, that's court type. Court name is United States District Court, District of Columbia, Circuit, D.C., Washington, D.C., case criminal, Victor Renato Blythe, defendant, USA plaintiff. I am so mad at myself for closing out that other website. So please forgive me for that. Did y'all know that he was a therapist who specializes in supporting individuals with anxiety and mood disorder through compassionate counseling and healing? I'm looking at his website, which shows that he did that, right? It makes me sick. I don't want to go to that website. I promise you, I do not. Okay, I'm going to do Victor Blythe. Go. Seeking victim information. It keeps trying to take me other places than where I wanted to go. So please forgive me for that. Somebody's trying to text me. I'm sorry, whoever's trying to text me. I cannot do it. I'm going to go into my email here. I wish I wouldn't have closed that down. No, don't leave this site. Go over here. Gmail. Sorry. Please bear with me. I'm going to play some music right here while I'm going over here and do a quick search, okay? So, y'all talk amongst yourselves, please. Okay, let's see. Yes, I got it. Thank you so much for bearing with me. I'm so sorry about that. So let me share this with you. Share screen. And you know what's sickening too? When you go to this website, then tomorrow or the next day, I want to do one on this Canadian sextorted USA children. Sorry, piece of crap. So here is Victor Renato Blythe, 61, in the District of Columbia, was sentenced to 10 years in prison in connection with his possession of 300 videos and 2,300 still images of child sexual abuse material, announced U.S. Attorney Janine Ferris-Pirro. Blythe was formerly employed as a psychotherapist and specialized in working with children and adolescents. Blythe previously was employed in the psychiatry department at Children's National Medical Center. Victor Blythe spent years hiding behind his credentials as a psychotherapist to gain the trust of vulnerable children, all while secretly collecting and trading the most exploitative images imaginable, said U.S. Attorney Pirro. He didn't just collect thousands of images of children being sexually abused, he encouraged others to exploit children. No sentence can undo the harm he caused, but this one ensures he is held accountable. We'll continue to pursue anyone who preys on children with every tool we have. I'm sorry I still get mad about he is held accountable. It's 10 years is not enough time, okay? I promise you, 10 years is nothing. Blythe was found guilty on May the 22nd, 2026, before Judge Dabney L. Rodriguez during a stipulated trial to the distribution of child pornography and possession of child pornography. In addition to the 10-year prison sentence, Judge Friedrich ordered Blythe to serve a lifetime of supervised release, to register as a sex offender, and to pay $71,000 in restitution. Federal prosecutors had requested a 188-month prison sentence. According to court documents, Blythe began to collect child sex abuse material in 2000 and attempted to sexually exploit children. For approximately 6 years, Blythe traded child sex abuse material with multiple people, including the person who was later arrested for child sexual abuse. In Blythe's communications with that other person, Blythe detailed his sexual interest in children and advised the other individual on how to groom children for sexual abuse. For example, the other individual told Blythe that he was video chatting with a 14-year-old child for the purpose of sexual abuse and was afraid he made the child uneasy. Blythe responded, "Keep chatting with him. He will get comfortable with you." Video chatting once again. Blythe also communicated, here's where I got this earlier, okay? Blythe also communicated with a minor child via Skype and told him to engage in sexual acts. During the conversation, the child stated that he was 15 years old, and Blythe responded, "So? That's hot." When the child stated, "It's illegal," Blythe replied, "Not for me." Blythe then sent the child a picture of his penis. So Blythe was saying that it's not illegal to mess with kids. He was saying it's not illegal to exploit the children. It's not illegal to send these guys these pictures, these young kids. It's not illegal for him to do all these things. He thought he was above the law. 10 years is not enough, people. No. People that's in higher power like this, I believe, should be an automatic death penalty. Blythe repeatedly discussed interactions he had with children in the D.C. area and his efforts to groom them for sexual abuse. You see that? On at least one occasion in 23, Blythe met a person with a minor child and offered to conduct therapy sessions with him. During one therapy session, Blythe asked the child about his sexuality and discussed his own sexuality with the child. Law enforcement reviewed Blythe's digital devices and found over 300 videos and 23,000 still images depicting the sexual abuse of children, including infants and toddlers. Anybody else agree with the death penalty with this? This case was investigated by FBI's Child Exploitation and Human Trafficking Task Force. With assistance from the Fairfax County Police Department, it was prosecuted by Assistant U.S. Attorney Rachel Blythe. This case was brought as part of the Department of Justice's Project Safe Childhood initiative. In February 2006, the Attorney General created Project Safe Childhood, a nationwide initiative designed to protect children from online exploitation and abuse. Led by the U.S. Attorney's offices, Project Safe Childhood marshals federal, state, and local resources to better locate, apprehend, and prosecute individuals who exploit children via the internet, as well as identify and rescue victims. For more information about Project Safe Childhood, please visit them. So here I am clicking on that and seeing. So maybe we need to go about that doing this another time. I think I did this as well, if I'm not mistaken. So there's about Project Safe Childhood, National Strategy for Child Exploitation Prevention and Interdiction. There's a press room, publications and resources, and contact us. Athens man sentenced to, and that's in Springfield, Illinois. There, see, there's an Albany man sentenced to 10 years in federal prison for possessing child sex abuse material. Then there's Athens man sentenced to 28 years in prison for child exploitation possession. Corvallis man sentenced to almost 20 years in federal prison for distributing child sex abuse material. Here it goes on. Former Joplin man sentenced to 33 years for producing child pornography. Former Nepal orphanage director indicted for illicit sexual conduct with a minor outside the United States. Former senior airman sentenced to 25 years for sexually exploiting children. So it just goes on, y'all. And this was 2026 right here. Y'all notice that? So there's more and more. If you look right here, there's more and more. It just goes on and on and on. I'm curious about this one because Jeff Webster County. No, that's in Alabama. Yep, it's in Birmingham, Alabama. All right, that's what I was thinking. What's this one about? Well, Jefferson County man pleads guilty to sexual exploitation of children after jury selected for his trial. Y'all, please be hyper vigilant around children. I'm asking y'all, please. I want to thank y'all for coming. Uh, God bless each and every one of y'all. And y'all have a great day. Stand up for our kids. You may be somebody's only voice, their only safety of getting out of this situation.